great personal and professional respect for the ranking member, but I think that his opening statement opened the door to a dangerous path. By rejecting the possibility of impartiality, the ranking member is effectively erasing the principle of separation of powers, which has been the bedrock of preserving liberty in America for 200 years. I hope that all of us at this dais agree that we have taken an oath to a Constitution that explicitly distinguishes between legislative, executive, and judicial powers. We as legislators are not judges, and judges are not legislators. They should not be making law, for if they're making law, they shouldn't have lifetime appointments. Under the American system, if they're going to be super legislators on the bench, then they should stand before the people so they can be hired and fired. And I think that that distinction is critical to some of the important debates that we have about the judiciary more broadly. So I respect the ranking member immensely, personally and professionally, but I think the position you articulated is actually a position that says that judges should be lawmakers, and then I don't know why they wouldn't have to stand for election.
Well, if I may have the chance to briefly respond, I think that what I attempted to do was to report from the judicial front what spectacularly respected jurists like Justice Cardozo, Justice Frankfurter, and Justice McKee have said about their work, and also report on what practicing lawyers report about their work every day. And the fact of the matter is that people who practice in court know that even at the district court level, there is plenty of opportunity for a judge to apply bias and prejudice and predisposition if they have it. And certainly at the appellate level, there's an enormous amount of making of the law that is described by judges who actually do that. And these are respected judges. These aren't people who've gone rogue. This is what the judicial function, in some cases, entails, particularly in a society like ours based on a common law that was entirely judge-made. So I don't stand second to anybody in the importance of separation of powers and the need to make sure that that separation is properly enforced. But I do think it is important that we not caricature the role of a judge as performing a rote or mechanical application of, quote, law to, quote, facts. To quote the remarks that I left, there is often play in the factual and precedential joints, and I think it's our task in this committee to make sure that that play is not an opportunity for the interference of bias, prejudice, or predisposition. But I appreciate your comments, and I have enormous regard for you as well.
Thanks. We will